It is possible to challenge a will, a contract of gift, purchase and sale, as well as any other legally significant action in civil proceedings, through psychiatry. The procedure establishes the inability to understand the nature and consequences of legally significant actions called forensic psychiatric examination, and if we are talking about the will, as a rule, it is held posthumously. Figure court proceedings on such issues in a simplified form is as follows. The statement of claim is drawn up. In the course of the session, evidence is presented. Petition for expert examination. And thereafter the order to carry out an expertise. The expertise takes place directly. The expert may request additional materials. Usually everything is limited to medical documentation. The expert report is read and examined at the session. The expert is interrogated. Arguments of the parties. The court makes a proportional decision. Attention, it is a simplified scheme from the position of a specialist in forensic psychiatry. It does not take into account all the features and pitfalls in the consideration of the case on the merits, the competence of the forensic psychiatrist and the lawyer. It is qualitatively different planes of knowledge. We strongly recommend getting the support of a professional lawyer in advance. By understandable logic, the key element in making a court decision that satisfies your interests will be the opinion of the expert. The quality of its conclusions will directly depend on the evidence provided and the personality of the expert. Conventionally, evidence can be divided into direct and indirect. Direct evidence is information from medical records describing a medical criterion, a diagnosis. Indirect, the specific information trace formed as a result of the life activity of the patient, which is in a direct causal connection with the disorder and, therefore, is evidence of the presence of pathology. The personality of the expert is referred to in the sense of a combination of his practical experience, qualifications, and degree of negligence with respect to the production of the examination. Experience and qualification assume that the expert is able to identify, trace and describe causal relationships within the framework of circumstantial evidence, but a high degree of negligence suggests that the expert, who at any rate will get his salary, will not bother with long laborious intellectual work and will substitute the examination of circumstantial evidence by stating the absence of direct, which lies in justifying the findings and subsequently is difficult to challenge, although in mathematical equivalent such justification by them in terms of frequency. This is a very common problem, and if we are not talking about a contract, there is no other option but to do all the work for the expert. In the end, your evidence and its interpreted documentary counterpart must be convincing and scientifically admissible. In this case, it will be easier for the expert to duplicate the ready justification than to make potential efforts to refute it. Gathering evidence, as with any other complex activity carried out by the plan in this case is a draft conclusion that is the content of which it is necessary to strive to litigate to get the desired result. It is drawn up as follows. On the basis of known facts, the medical criterion of incapacity is supposed to be a diagnosis. Each diagnosis has a list of diagnostic criteria. For each criterion, evidence is collected and a rationale is formulated, revealing the logical relationship. They, in turn, in the summarizing part, collectively explain the legal criterion of incapacity. The criteria written out in full in this way correspond to the justification in the conclusion. In this way, the evidence is collected and presented objectively, including not only the documentary evidence, but also the accentuated interrogation of the witnesses. With the completed draft report in hand, it is possible to verify and potentially link the certification organization with the evidence from the investigation, and it is also possible to do this during the preparatory phase. Do not rush to write a statement of claim. The duty of proof, it is your problem, and no one will understand something there if you do not do it yourself. The first step is to find a team with all the qualities for effective participation in the process. If an active lawyer already have, then in terms of judicial psychiatry can knock on our contacts under the video.